All right, let's go on the record in the matter of 23R2033GC, which is 33rd District Court case, Lisa and Peter Darville versus HR&E Masonry and Christopher Wampler.
Morning, Your Honor. Attorney David Lechner, P number 67994, on behalf of plaintiffs, the Darvilles.
Thank you.
John Dickey on behalf of the defendants, Your Honor.
Okay, all right, thank you. And so, yes, the court is in receipt of defendant's motion for leave to file third-party complaint. Mr. Lechner, is there an objection to that on the part on behalf of your clients?
Not an objection per se, Your Honor, because I believe, and I've spoken with my clients and I've spoken with Mr. DQ about this, I believe additional pockets only help my clients in this matter. I don't know if it's the materials or the workmanship or a combination of both that are causing the issue with my client's property. I would, however, ask for because the only thing I will say is this does prejudice my clients a little bit because if the defendants are allowed to bring in a third party, it draws out the timeline. So this was filed last June or July. It's now a year later. We're bringing in a third party. That third party is going to want to hire counsel. They're going to want discovery. They're going to want, so it's going to drag this out even longer. And well, again, I believe that ultimately that might be to my client's benefit. I could see how this should have been done a while ago. I don't blame brother counsel. But I think he has difficult clients. And to that end, I would ask for a bond from the current defendants to be held with the court in escrow towards any possible either judgment or resolution because my clients are sitting on bad concrete and they can't afford to replace it. So we would just ask that the defendants put up a bond towards any future resolution or judgment.
Okay, and Mr. DQ, your response to that request regarding the bond?
Well, it's the normal stuff, Your Honor. You know, why are we paying money into something before any liability's been found? The bond, I don't know what exactly that's going to accomplish here because it wouldn't be released until the thing was resolved as well. I'm going to say there isn't any ill will or anything on this side. I'm going to say the amount of effort being put forward in going forward has been a little bit lacking.
Well, and so let me just make a statement. The court will note that this matter was filed on July 17th of 2023. On August 3rd of 2023, Judge McNally recused himself as Ms. Darville is Judge McNally's judicial clerk. And so the court's aware that at that point then, there needed to be the appropriate paperwork filed with SCAO, which was done on August 7th. The request was referred to SCAO on August 9th by Judge Hessen. And I'm not sure when we received the reassignment. Let me just see, because somehow all the stuff isn't. I know that the November 3rd pretrial phone conference was conducted here at this court. And it was set for a final pretrial on February 2nd. I don't know what happened on February 2nd because the only notes I have are from May 3rd. I don't know if it had been adjourned, but this court on October 4th set forth a scheduling order where there was to be dispute resolution. Was there a mediation that was conducted?
No, Your Honor, there was discovery. I sent out interrogatories. I eventually got responses to the interrogatories, and then I believe we adjourned February 2nd to try and work something out, and it wasn't fruitful. And again, This isn't a reflection on council. I believe Mr. DQ and I are working well together to try and resolve this. It's not easily resolved at this point.
No, and I can understand that, but also at the same time, this court sets forth scheduling orders for the purpose to make sure that the case is moving along and discussions are being had. And so this court ordered that dispute resolution should have been scheduled by November 17th of 2023. And that wasn't done. Perhaps that could have been effective in helping to resolve this matter or knowing where the issue potentially lies. Whether it's a workmanship issue or a product issue. And so that wasn't done. And so my notes, when you all appeared on May 3rd, my notes show that defendant was having Messina Concrete go to look at the concrete, as Messina is where the concrete is purchased from. Then the attorneys were going to chat and return back today. So did the two of you chat after Messina Concrete went out to look at the property?
I can explain a little bit of that to you, Judge, because I'd say we have talked, but Messina did not go out to the property. And according to my client, he is no longer allowed to purchase concrete from Messina because Messina was upset with him, asking, probably demanding that they go out to the site to view the concrete.
Wow.
And hence that has now required, I even talked to Mr. Lechner about it. It's like we could go I would probably gentlemanly is not the politically correct term to use anymore. I don't know which term to use, but I could reach out to Messina and say, hey, we're going to bring you into this thing if you don't cooperate. But Mr. Lechner and I, after years of doing this stuff, have decided that really doesn't get anywhere. Really need to bring them in on a third party action, and that'll get some behavior out of Messina proper. But I agree with Mr. Lechner, it's going to drag this thing out a bit, and trying to be cognizant of what his client's position is and what the status of the concrete itself is.
And I would say, Your Honor, that in conversations I've had with Mr. TQ, so this isn't coming out of left field, we could, if his client was amenable, we could resolve it right now, and then he could subrogate against Messina on his own and start a new clock all over again. But I'm not telling Mr. DQ how to practice law. It's just an option. But I can understand why he would rather third party them in now, because then perhaps takes the onus off of his client if there is a finding of fault against Messina right now.
Potentially. And the court will also note that there was a January 31st order that did extend the discovery dates and dispositive motion cutoff dates and final settlement conference dates. And so the court had granted that. And so here's what I'm going to agree with, is that clearly if Mr. DQ were to contact Mr. Messina Concrete to say either participate or either participate voluntarily, or I'm going to make you participate, right? They're not going to voluntarily participate, and it's dragging out even further. So, and the court is very much aware in these types of cases that it's a workmanship or product issue, but we won't know that until the proper discovery is obtained with regards to the concrete. I know there's a certain type of mix, there's a certain type of everything right now. Is it possible that Messina is going to say, oh, well, defendant didn't do it properly? Probably, but there's going to that'll be a question of fact that we'll have to determine. And maybe they'll admit that there was something wrong with the concrete. I don't know. So, but the court does find that the third party, pursuant to MCR 2.204A1, that it would be appropriate to allow a third party complaint. And so the court will grant that motion. The court is not going to order or require a bond in this matter, is I don't find that this request to file a third-party complaint or anything going on in the interim has been what's the word I'm looking for? Not frivolous, but it's been diligent. And so that this is not a frivolous request. So the court's going to, so that's the order of the court.
I got to clean up something real quick. Sorry. So the paperwork that I forwarded over to you, that motion is actually not filed with a $20 fee with your clerk yet.
So to confuse things even more, you'd have to file that fee at the 33rd District Court.
Oh, wonderful. That's not directed at you.
Oh, I know. It's just not a very clear.
Well, let me ask this. Is Mr. Luckner, would you be comfortable with signing the stipulation that allows for it? And I'll still give the $20 over to the 33rd.
But hold on. So here's what I'm going to do. I mean, instead of getting into a lot of verbiage and whatnot, I'm going to presume, based on Mr. Luckner's argument, that he's not going to agree to a stipulation, because then he has to report back to his client that that's what, in fact, he did. This way, everybody could just say that the court ordered this. But Mr. Luckner, I don't want to speak for you. I was just gauging what you stated in your argument.
No, I understand. And what I will say is Mr. GQ has already drafted an order granting leave to file a third-party complaint. The court's ordering it. I can stipulate to the language in the order that the court, just for the purposes of form only, and the court can then sign it. And then, since the court's already made their decision, I don't have a problem doing that. That I think that gets rid of the having to do a 7-day order.
We could actually doctor that up under the stipulation part and say that you agree with its entry and your objections are on the record.
That's fine. I have no problem with proceeding that way.
Okay. So the order that's submitted, I'm not signing. You're going to submit a new order with that language, correct?
I will do that. Yes.
Okay. All right.
You can sign my name to that, Mr. TQ.
Thank you, Mr. Luckner.
Okay. And so then what I'm going to do then, counsel, is I'll issue a new scheduling order once the 21 days is expired. If Messina Concrete files an answer or whatnot, the court will then submit or put forth a new scheduling order with pretty stringent times that are not necessarily going to be flexible.
Understood.
Thank you.
Okay. Anything else?
No. Thank you, both of you. Have a great weekend.
All right. Thank you. Have a good day.
You as well. Bye now.
Off the record.
Yep. Okay. Go. You hand me my screen box.
Robert. Now go. Freak.
Okay, so Ms. Casey and Mr. Montaloro, I did pull you out of the breakout room. Were you still communicating, or were you all done and ready to proceed?
I didn't speak to him at all.
Well, ma'am, that's why I put the two of you in a breakout room. I stated I was putting the two of you in a breakout room so you could have a discussion.
Well, there was no discussion.
So the two of you had just been sitting in the breakout room, not doing anything?
Waiting for you.
No, I wasn't joining you. It was for the two of you to have a discussion. All right, well, the court's going to go on the record in the matter of Sandra Casey versus David Montaloro, 2400743. And Ms. Casey, your name for the record, please.
Sandra Casey.
Okay, and Mr. Montaloro, your name for the record, please.
David Montaloro.
Okay, and today's the date scheduled for the first hearing in this matter, and the two of you reside together, correct?
Yes.
Okay, and so what is the relationship? Are you family members, or what is the relationship between the two of you?
He is my daughter's ex-husband. They were divorced in January of 2023, and he has never moved out. She got mad at me because of not doing this sooner and moved out June 2nd. So now I am living in this house with him.
Mr. Montaloro, why have you not relocated?
Well, I've been busy with working and trying to take care of the kids as much as possible, and helping my ex-wife with moving, and
Well,
I've been
sir,
trying to be productive, Your Honor.
okay, I would think that knowing that so you've been residing with your ex-wife and her mother for a year, almost a year and a half?
That's correct.
Isn't that a tad uncomfortable?
Well, I have hope for the best, that things could turn around sometime.
Well, sir, Miss Casey doesn't want you to continue to reside there. So what are your plans?
I just was helping with a lot of big items moving, and I'll try to work as hard as I can to relocate. And I just would ask for just a little bit of time. There's a lot of heavy equipment and tools, and a lot of the tools were used to repair the family residence there. Some of the items included the whole entire furnace and air conditioning, among other things.
Okay, hold on, sir. Hold on just one moment. Are you telling this court that you couldn't relocate because you said that there are a lot of big expenses? What are those big expenses, sir?
I used a lot of money and personal time and skill and effort in fixing and repairing and taking care of the residents there for me and my family and the mother-in-law. And I also have accumulated tools, machines that are a little difficult to move.
Okay, so sir, how much is it that you have put in the last 15 months? How much money have you put into repairs or whatnot at the home?
Probably a couple $1,000s worth.
Okay. Okay, and Miss Casey, you're shaking your head no.
No. He had, they put the new furnace and air in 2018 when my daughter was pregnant with her last child. Okay. They did that. They bought things, but they used it. They've lived in my house before 2008. And then they moved to Lansing for a year, then moved back to my home.
Okay, so let me ask you this, ma'am. Since January of 2023, has there been any monies paid by Mr. Montaloro for anything at the home?
No.
Not one penny?
They agreed to pay the phone bill and the car insurance, which all of the cars are in my name.
Okay, well, I'm not referencing those.
Okay.
I'm talking specifically the house repairs, house remodel, house anything.
No.
Okay. Mr. Montaloro, since January of 2023, have you paid any money towards the home?
Yes, I've tried to fix things when they break, and I've also tried to pay all the household utilities, maintaining.
Okay, well, sir, quite frankly, that doesn't, that's not something that I'm looking for. You testified that you had spent a lot of money on big ticket items, and it appears though those big ticket items were prior to January of 2023.
Well, one of the bigger new ones was the new washing machine. That was about a year ago. And that was $1,000 for that.
Okay, all right. So, sir, you're saying that you need a little bit more time. What does that mean in your mind?
I believe if I had until the end of this month, I could move all the large items.
Okay. Ms. Casey, are you in agreement to allow him until June 30th?
No,
Okay. So, the statutory 10 days would be June 17th. And you don't want to give him the extra 13 days to move his items out?
Your Honor, he has had all this time. He has property at Manitou Beach, Devil's Lake. He has a home there that burnt down a year and a half ago, and he had no homeowner's insurance. He has a place. It has he put a new roof and windows on. He could move there.
Hold on,
Okay.
just for a moment, just a moment. You said it burned down. Was it rebuilt?
It was gutted, and the frame is there. The roof is on. They have new windows.
Okay, well, what about electrical or?
Yeah, I have.
When did you serve Mr. Montaloro with the notice to quit?
April 8th, 2024.
Okay. So, sir, you've had 2 months to relocate and to look for a place.
Well,
What steps have you taken, sir?
I was a little tied up with helping the ex-wife move and getting furniture and large items moved for her. And also, Mrs. Casey did text me about a leaking faucet plumbing fixture that I just fixed a few days ago. And there was also a utility bill for the house, and she left that out for me, and I paid the utilities for the house. So that's why I was just requesting to
How much were the utilities that you just paid, sir?
$266.
Okay, was that paid by Mr. Montaloro, ma'am?
I haven't checked into it yet, but it was the receipt.
Did you leave the bill out for him to pay?
I had it sitting out. I don't know if he paid it or not.
Okay, was the expectation that he was going to pay it?
No.
That was not the expectation. Okay. And so, sir, why did you buy furniture for your ex-wife for where she was relocating to?
Well, like I said, I really still like her and enjoy spending time with the family and taking care of not just the children, but trying to help her to have an easier life. And she works really hard for the Ford Motor Company, and I don't want to be selfish and only focus on my own goals, but I try to help her and help the mother-in-law with the house, the repairs and utilities and bills and things too.
Okay, well, sir, that's going to have to be their own responsibilities because you have until June 17th to relocate. Ms. Casey doesn't want to allow you any additional time.
No.
And ma'am, please don't interrupt. Okay.
I'm sorry.
She doesn't want to allow you any more time. And so the court hasn't really found any legal basis to extend the statutory time past June 17th. So, sir, you're going to have to focus on yourself and they're going to have to figure it out for themselves. So the court does find by hearing that the plaintiff has the right to recover possession of the property, that the plaintiff may apply for an order evicting the defendant if the defendant does not move out on or before June 17th. And no money judgment will enter at this time. And ma'am, don't ask him to fix anything else.
Your Honor, he has destroyed my home. What he fixed is a hose that he constantly sprays with and broke it himself. He has not fixed anything for me. It's stuff that he uses.
Okay, I don't know what a hose. I don't know what that is.
The kitchen sink, the sprayer.
Nobody else uses the sprayer on the kitchen sink?
No.
Okay. Well, for whatever it may be, Mr. Montaloro's money has to go towards relocating because he has 10 days to do so. If you may file a motion for a new trial or set aside the default judgment within the 10 days. Okay. All right, thank you. Anything else?
Can I say one more thing, Your Honor? When,
The court's already issued its ruling, ma'am. What else would you
well,
like
I
to say?
want to say, when Randy Miller came to serve him, he hid. And
Ma'am,
then,
ma'am, none of that is relevant at this point. I've already entered the judgment.
okay, no problem. Thank you.
All right, thank you. You have a good day.
Yep.
Thank you.
mhm.
Thank you. All right,
You
and we
too.
are on the record in the matter of the city of Wyandotte versus Vanessa Bell, 24725 and 193244.
Attorney Corey Westmoreland appearing on behalf of Ms. Bell. Ms. Bell, would you please state your full name for the record?
Vanessa Bell.
All right, thank you. And so today is the date that we're going to conduct the arraignment on the current matter, and then an outstanding matter from July 19 out of Riverview, as your client is currently in custody. And so, counsel?
Yes, Your Honor. I would like you to know that Ms. Bell currently is residing in River Rouge. She's not currently on probation or parole. I don't believe she has any other matters other than these pending out of this court. And after speaking with her at length, she did assure me that she would be appearing at all future court dates. I just ask that all that be taken into account when assessing bond on behalf of Ms. Bell.
All right. And so, what is your, actually, the court will waive the formal reading, enter a plea of not guilty, schedule the 193244 matter relatively quickly. We're going to do June 10th, which is Monday at 10:40 a.m. And on the Wyandotte matter, the court will also waive the formal reading, enter a plea of not guilty, schedule this matter for pretrial on June 26th. And ma'am, where in, what is your address in River Rouge? Because we have a different one. That's FAIRMONT, correct?
Yes, Your Honor.
And what is the zip code?
I'm not sure 48. I'm not sure. I'm not really sure what the zip code is. I just moved there like 2 weeks ago.
Okay, and who do you live there with?
Jesse Ramirez.
Where do you work?
I am currently not working right now.
Well, when were you last employed?
Probably about 5 years ago. I had an issue with my employer, and I had to sue him, and it's caused a lot of mental anguish with me, and I haven't really been back to work since.
Well, ma'am, how are you supporting yourself?
My mom helps me out, and I was staying with my fiance passed away last year. I was staying with his family, and his family took care of us.
Who's us?
Me and my fiance that passed away.
So, ma'am, with all due respect, how old are you?
I'm 43.
43. And so when I asked how are you supporting yourself, you told me your mom helps you out, and then that you and your fiance, your late fiance, had lived with his family. So you're not supporting yourself at all. And
I don't leave the house. I had a fear of leaving the house for a long time. So I'm just now kind of getting out back into the world.
And when did you start getting back out into the world, ma'am?
Probably like 4 months ago, maybe. I started to kind of venture back out in the world.
Okay, well, ma'am, if you were to test today, what's in your system?
Probably methamphetamines and weed.
And you don't have a valid prescription for either one, would that be correct?
I have a prescription for Adderall.
Okay, but you don't have a prescription for methamphetamine, you don't have a prescription for marijuana, is that correct?
Oh, ma'am.
Okay, and so why haven't you appeared in your matter out of Riverview in this court?
My dog had attacked another dog, and the city had taken my dog for about a month. And when I went to court, and they told me that I could have my dog back, I went and picked him up, and they had neglected him so badly I had to put him down. And it's just been a very hard last 4 years, and I just didn't deal with it because it was hard to deal with. He was my emotional support dog.
All right, well, here's what the court's going to do. Based upon your previous failure to appear on the 193244 matter, the court's going to order a $3,500 10% bond. You're not to possess or consume any alcohol or drugs unless prescribed. And On the 24725 matter, the court's going to order a $3,500 10% bond. In the event you post bond, ma'am, you're not to possess or consume any alcohol or drugs unless prescribed. You're to have a GPS tether, and you're to participate in random testing. Any questions?
How much is the bond?
Well, between both, it would be $700. And given your previous history of failing to appear and the allegations that are in these matters, that's a relatively low bond, ma'am. And in the event that you post bond and you are released from jail, you need to then contact probation to set up your testing, ma'am.
Okay.
Anything else, counsel?
Not this time, Your Honor.
All right, thank you. Have a good day. Good luck to you, ma'am. All right, let's go off the record. So, on the record, in the matter of the city of Wyandotte versus Cody Chiccothelli, 24726 ABC. And counsel, your appearance, please.
Attorney Corey Westmoreland appearing on behalf of Mr. Chiccothelli. Mr. Chiccothelli, would you please state your full name for the record?
Cody Chiccothelli.
All right, and good morning. Today is the date scheduled for the arraignment as your client's in custody, and so counsel?
Yes, Your Honor. At this time, we are prepared to waive a formal reading. My client stands mute.
All right, the court will waive the formal reading, enter plea of not guilty for purposes of the arraignment. Schedule this matter for pretrial on June 26th at 11:10 a.m. And counsel?
As to bond, I would like you to know Mr. Chiccothelli is currently residing in Detroit. He's not on probation or parole. He has no pending matters out of any other courthouse. He is currently gainfully employed at. After speaking with him at length this morning, he did assure me that he would be appearing at all future court dates, and he has never failed to appear or absconded from any honorable court. Judge, I just ask that all that be taken into account when assessing a bond.
All right, thank you. And sir, how long have you worked at? Okay, where's that?
It's in New Boston.
Okay, how do you get back and forth to work every day so you don't have a valid license?
I usually my fiance drives me out there. We both share the car, share the vehicle.
Does she have a valid license? Well, you can't both share the car, so you don't have a valid license. So
I'm saying she drives me to work and then uses the car to drive to her job.
Sir, let me clarify. I wasn't born yesterday, so I'm sure that you've been driving back and forth to work, especially based on what you've just stated, and the fact that you were arrested for driving while license suspended. So, so the fact that to say that you don't drive is not very forthright. So, sir, if you were to test today, what's in your system?
Just fentanyl, that's it.
Just what?
Just fentanyl or
Fentanyl.
yeah.
Are you prescribed fentanyl, sir?
No, ma'am.
Do you
That's
want?
what I got caught.
Okay. Do you want to continue to be able to go to work and live?
Yes, ma'am.
And I suggest you stop using fentanyl. I'm sure you're very well aware, sir, that fentanyl is highly lethal, correct?
Yes, ma'am.
And you're not currently on probation or parole anywhere, sir?
No, ma'am.
Are you out on bond in any other jurisdiction?
No, ma'am.
All right, here's what the court's going to do. The court's going to, based upon the allegations and such, and sir, you seem to have a tough time following the law, so I'm hoping you can follow the court order that you're not to operate a vehicle without a valid license. The court's going to order a $2,500 10% bond. You're not to drive at all unless you're cleared by the Secretary of State. You're not to possess or consume any alcohol or drugs that are not prescribed. And you are to participate in random testing, sir.
Okay.
Are you expecting to post bond?
I should be able to. What would that be? $250?
Yes. So you are to report to probation upon release so you can get set up for your testing.
Okay.
If you do not, sir, that would be a bond violation.
No, it's fine. I'll report.
All right. Anything else?
No, ma'am.
All right. Have a good day. On the record, in the matter of the city of Wyandotte versus Michelle Bolinsky, 24728. And counsel, your appearance, please.
Attorney Corey Westmoreland appearing on behalf of Ms. Bolinsky. Ms. Bolinsky, would you please state your name for the record?
Michelle Ann Bolinsky.
Okay, and the court, counsel, as to the arraignment.
At this time, Judge, we waive a formal reading. My client stands mute.
All right, the court will waive the formal reading, enter plea of not guilty for purposes of the arraignment. And we're going to schedule this matter for pre-trial. I think June 26th is not looking good. At 11:30 a.m. All right, and counsel adds to bond.
Yes, Your Honor. Ms. Bolinsky currently is residing in Southgate. She is self-employed. She works for herself, cleaning homes and painting them. She's not currently on probation or parole. She has no pending matters at this time. And after speaking with her at length, she did assure me that she would be appearing at all future court dates. So I just respectfully request that all be taken into account when assessing a bond on behalf of Ms. Bolinsky.
Okay, ma'am, have you been here before?
No.
No, okay. And so you clean homes, ma'am? Or,
Yes.
okay, and how long have you been doing that?
3 years.
All right, and have you ever failed to appear in court, ma'am?
No.
And you're not on probation or parole anywhere?
No.
Are you out on bond in any other jurisdiction?
No.
Who lives at the home with you?
My friend and her husband.
And how long have you lived there?
It's just been a few months, 3 months.
Okay, and why, and where did you live before that?
In Wyandotte, in an apartment.
Okay, and so what happened with that?
Well, I put a 30-day notice in, and then my plans where I was gonna move didn't fall through, so, but the landlord had already rented the apartment out.
All right, and if you were to test today, ma'am, what's in your system?
Nothing.
All right, are you prescribed any medications?
No.
All right, based upon the allegations in this matter, the court's going to order a $2,500 10% bond. You're not to possess or consume any alcohol or drugs unless prescribed. And you'll be subjected to random testing, ma'am.
Okay.
All right, are you able to post that bond today?
No.
Okay, well, let me make a note that you are to contact probation upon release, whenever that may be. All right, thank you. You have a good day.
You too.
Calling the matter of the city of Wyandotte versus Suzanne Murphy, 24727.
Attorney Corey Westmoreland appearing on behalf of Ms. Murphy. Ms. Murphy, would you please state your full name for the record?
Suzanne Murphy.
All right, and the court, counsel as to the arraignment in this matter.
At this time, we are prepared to waive a formal reading. My client stands mute.
All right, the court will waive the formal reading, enter a plea of not guilty for purposes of the arraignment, and this matter, and we'll schedule this matter for pretrial on June 26th at 11:45 a.m. Counsel, some of these dates might actually change. We might move them up to this Tuesday or this Wednesday, but I don't know. I think our June 26th docket is getting very full. But we'll see. If we do, we'll make those corrections on the information that the defendants receive. All right, and counsel as to bond.
Yes, Judge, I would like you to know that Ms. Murphy currently is residing in Detroit. She works at the Tipsy Fish and Grow Seal and for Amico gas station in Highland Park. She's not currently on probation or parole. She has no pending matters. She's never absconded from any honorable court, and she did assure me that she would be appearing at all future court dates. So I just ask that all that be taken into account when assessing a bond.
Okay, ma'am, you live in Detroit, you work in Groseal and in Highland Park?
Yes.
And are you currently on probation or parole anywhere?
No, ma'am.
Okay, so what happened with your most recent Third Circuit Court matter? Did you complete probation?
Yes.
What happened with your matters out of the Third Circuit Court that occurred in Livonia, it's alleged, back in 2021? What happened with those matters?
It's all completed. I did everything I was supposed to do for that.
Okay, so did you plead guilty? Were you found guilty? I'm not showing anything in here.
I thought it was all done and taken care of.
Was it dismissed or did you plead guilty or found guilty and then you were on probation? What happened?
I believe I took a plea and then completed whatever they asked me to do.
Okay, and you weren't in custody for any of that? You were all, it was probation or were you incarcerated?
It was probation.
Which is very curious given your criminal history, ma'am, and the number of felonies and the assaultive behavior and the drug convictions that you continue to get probation.
I understand, and I know it looks bad, but I'm just trying to live better, and I really don't want to lose my jobs.
Ma'am, you already have prior convictions for felony drug matters.
I have one, yes.
Yes. And now here you are with another drug charge. If you were to test today, ma'am, what's in your system?
Fentanyl would probably be the only thing. The doctor always wants me to take a bunch of pills, and I don't want to take a bunch of pills.
But you think fentanyl, which is very lethal, is the thing to do?
It's the only thing that like takes my pain away. I don't know what else to do. It's the only thing that I can work on my feet 12, 13 hours a day.
Ma'am, perhaps you want to find a job that you don't have to work on your feet. That would be that'd be one option, which I know it's not super easy to do.
I don't know how else I'm going to support myself.
Is that your husband or your boyfriend, Mr. Chiccothelli?
He's just my friend.
Well, here's what the court's going to do. Given your criminal history, given the nature of the charges, the court in this matter is going to order a $5,000 10% bond. You're not to possess or consume any alcohol or drugs unless prescribed, and you'll be subjected to random testing, ma'am. I'm not a doctor. I can't tell you what medications to take. But I'm a judge, and I can tell you that you cannot use any illegal medication, ma'am. Fentanyl is illegal and life-threatening, quite frankly. So upon posting your bond, ma'am, you need to report to probation so that you can get your information regarding testing.
I don't have a way to post a bond, so.
Okay, well, at least we know that you'll still be alive because you won't be using fentanyl. All right, thank you. All right, and we are.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. This is a joke. Today is an absolute joke. We need an interpreter.
I need an interpreter when I cannot express myself sometimes.
Joke. Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Reed? We're going to start bringing people in person. People are going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it?
No.
Okay.
I have no patience for that. And trust me, out of the day, I'm sitting up here, I'm the one that needs a drink.